These are heard appeals in the matter of HMRC and AXA Sun Life PLC and others, and AXA Sun Life PLC and others, and commissioners in Birmingham and others.
Yes, Mr. Bremner.
I'm obliged, my lord. Yesterday I'd finished with FII High Court 1.
Yes.
Please may I now turn to FII Court of Appeal 1, which should be in volume 2 of the authorities, tab 27, starting at page 601. And there's a very lengthy index of the issues that this court was deciding at 602. And
yes.
Happily, I can pick it straight up at issue 11. I'm only going to need issue 11 and issue 13 and only very little bits of both. Issue 11 is set out at the bottom of page 654.
Yes.
That is looking at whether the claims were within the San Giorgio principle. And in relation to the reliefs, the claimant's argument that the San Giorgio principle applied is rejected. One can see towards the bottom of paragraph 149, which is on page 665. It's really the final sentence, but that's all I really need for my purposes when the court refers to the use of group relief and management expenses being the result of tax planning and commercial decisions within the discretion of the claimants. That was why they were excluded from the San Giorgio principle. When we look at the Supreme Court, we'll see that that reference to discretion, that actually was wrong, certainly so far as management expenses were concerned, because they were applied automatically under the operation of the statutory provisions. But I'll come back to that. So the argument failed as a matter of EU law, save in respect for ACT set against the unlawful case 5 charge, which was held to succeed in 151. That, of course, was the ruling that was overturned in Prudential Supreme Court, and my learned friend showed your lordship some of the passages in Prudential Supreme Court, and I'll come back to that when I'm dealing with the income tax set-off issue C3. So on particularly group relief and management expenses, the claimants didn't get home under EU law. They also tried under English law, and that was issue 13, which your lordship will see on page 672. Sets out the issue. And I can do this very briefly because we touched on this, I think, both with my friend Mr. Hewitt and my friend Mr. Wilmot Smith. This was where the claimants, paragraph 178, they set out their argument by reference to these various, they were called constructs. So that was a slightly odd word perhaps, but different ways of analysing what was being asked for. And those constructs were set out in paragraph 178. I don't need the detail of them. 1 to 3 focus on the use of the reliefs, analysing the enrichment and the mistake in different ways by reference to year 1 or year 2 or later. And then the 4th construct is the declaration that was sought just above the start of paragraph 179. And those arguments were all rejected in paragraph 179 on page 674, with the exception of the lawful ACT utilised against unlawful MCT.
When you look at the constructs, do any of them reflect the way in which you now want to put your case?
They're all slightly different to this. So there isn't an exact match between any of constructs 1 to 3 and what the Supreme Court ultimately held to be the case in Salon. And the reason for that is what you'll see is that the mistake focuses on the use of the reliefs.
Is it not the third? I don't quite understand why it's not the third construct.
It's the closest one is the third one. It's not absolutely the same, but it is very, very close to the third one. That's right.
Do we need to understand why it's not quite, why the third construct's not quite right?
Not for my purposes, because my submission, as we'll see, is that regardless of this history, that the history is important for then looking at the pleading and understanding what it is that's sought to be claimed. But my point is, regardless of how the case was argued out in the Court of Appeal in 2010 in FII, what has been pleaded when we look at it in 2003 and 2009 in particular is broad enough to capture the claim that's now been held to be available. So it's not as if we're tied in to the very specific formulation of those constructs. Just to answer my Lord Justice Nugee's question, if one is being very pernickety about the third construct, the reason one would say that it did not apply is that one would say that the reliefs were in fact validly used. The mistake was in not realising that there was double taxation relief available to be carried forward.
Yes,
The reason why I say, actually, there might be an argument about whether it applies or not, DTR is just another relief. And so actually, although it's a slightly different description of what's happened, the carrying forward of the DTR, it is the other side of the coin of the reliefs being expended. Because if the system had worked as it should have done, the DTR would have been there to have been applied in year, but of course it wasn't.
Presumably it's not interchangeable, because otherwise there wouldn't have been the later dispute about which was the right approach to take. As I understand it, from the discussion we had earlier, there was a real dispute about.
And I'm going to show you, Ladyship, that.
I know. So what it means is it gives rise to a really different result, as I understand
it gives rise to a different route, and it gives rise to a different characterisation of the unlawfulness. But the two things are very closely related, as we'll see when we look at FI Supreme Court 3. But I hope that's an answer to the question. At least I can then answer more fully my Lady Justice Falk's question when I look at Supreme Court 3. I don't need the detail, because what the court then does, and we haven't looked at this in detail, but we don't need to because the law's moved on, but they deal with each of the constructs in paragraph 180 to 184. And just put short, on constructs 1 to 3, for various different reasons, it is held that there are problems with the arguments either on enrichment or on the unjust factors. So it said, well, either there's no benefit that's capable of generating a restitutionary claim, or alternatively, tax that was paid, well, it was lawfully due. So what's the problem? That's a very boiled down description of paragraphs 180 to 184, but broadly they're the two reasons why the constructs 1 to 3 are rejected. And then on construct 4, declaration, it's said, and that this was on the basis of the understanding at the time, but life again on this has rather moved on. It said, well, you can't have a declaration because that's a statutory matter that would have to be dealt with in the appeals procedure. That's paragraph 184. But we now know that the statutory procedure doesn't exclude High Court claims. So that was where things stood in 2010. These claims had been rejected. There was an application for permission to appeal by the claimants. That application was held over for a number of years before then these issues were dealt with in FI Supreme Court 3. And in the meantime, we had Salonen, which is what I should show the court next. And we can put away volume 2. And Salonen is in volume 4 of the authorities, divider 42, page 1541. This is actually the report of a decision in two different cases that were joined in the Court of Justice. The first was Haribo, and I don't need to say anything about Haribo. It occupies much more of this report. Salonen raised two particular questions, and one of those is relevant to the issue that this court needs to decide, and the significance of it, as I've already hinted at, is that what Salonen does is it shifts the focus of the claims in respect of the reliefs.
In respect of,
I said in respect of the reliefs. It means we're no longer looking directly really at year one and at use of reliefs. It's now much more about the taxation applied in respect of the dividend income. And as we'll see, the vice was that it's the original overseas dividend income that is being subjected to economic double taxation in circumstances where that is not happening in relation to dividend income from a domestic resident company. The court's judgment, don't need to start here, starts at page 1578, but I can pick it up on page 1603, paragraph 148, which is the court's summary of the questions that were put to it in Salonen. And what one sees in 148 is the court looking at a tax regime. It happens to be the Austrian regime. Like the UK system, what it did was it exempted domestic dividends. By that I mean dividends paid by domestic resident companies, but if I can just use the shorthand. So they were exempt. Dividends for non-residents, they were subject to tax, but with credit for foreign tax. And the question really was whether that regime was required to permit carry forward for use in future years of double taxation relief credits on non-resident dividends if the credits couldn't be used immediately because the company receiving the dividends had losses which had been set off against the foreign income. And the problem, of course, is if you're looking at this in a comparative way, for the domestic dividends, there's never going to be any such problem because the domestic dividend income is just exempt. No reliefs are going to be expended. The reliefs then in a later year, they'll be available to be used as and when there are profits. And so there is unequal treatment. What the court does, having dealt with admissibility, is get to the substance of the question in paragraphs 154 and following. In its reasoning, it starts, paragraph 156, page 1604. That's the classic requirement for equivalent treatment, and that's the basis of all of this debate, really, ultimately, is that the fundamental principle that to comply with, in this instance, Article 63 in the free movement of capital, there needs to be equivalent treatment of domestic dividends and overseas dividends, and they cite for that the ruling in FII.
That doesn't mean you have to have the same.
That's right. It doesn't have to be the same, but it must be equivalent. And what the court is doing here is telling us what that equivalence involves. That's absolutely right. And the significance of that is it means that it's not enough to say the treatment is not the same because you're exempting the domestic dividends and you're having a credit system for the overseas ones. You have to look further and say, yes, it's different, but is it nonetheless equivalent? And what the court is doing is identifying a further respect in which equivalence may be breached. And what we see is that respect also applies as much in the UK as it did in relation to the Austrian system. And the court sets out its summary of what the Austrian system was doing in paragraph 157. And so the dividends, they're included in the tax base. And so the amount of the loss that you would otherwise have to carry forward, that's reduced. And then the contrast is drawn in the final sentence with the domestic dividend. Paragraph 158. Is the court making the point that that results in the economic double taxation of the foreign source dividends, that's a short summary of the very long first sentence. And then the contrast is drawn in the second and final sentence in paragraph 158 with a position for nationally sourced dividends. There's no risk of economic double taxation for them, and that's because of the application of the exemption method. And then 159, what does this actually do on the ground? If one reads to the top of 1605, the reason this matters is that that results in higher taxation for the overseas dividends than the domestic dividends. That's the vice. And then paragraph 160, it's in the light of that, in the light of what's stated in para 156, so that's the need for equivalent treatment, Article 63 precluded the Austrian legislation. So the problem that you had in Austria was that that tax liability on the dividend income, in effect, that tax liability was postponed until in a later year there were profits and a tax charge arose. And as the court points out, if the foreign income had been exempt, like the domestic income, the losses would remain available and they would shelter that later liability. That's why there was a differential treatment. That's why there's the breach of EU law. What one mustn't lose sight of is that the problem is one of the taxation of the overseas dividend income, and that is important when we look at what's been claimed here. So as we saw looking at FII Court of Appeal 1, prior to Salonen, the focus was on use of reliefs against the year one tax charge. What Salonen provides is a different way of looking at the problem, that actually what's happening is that there is indirect double taxation of the overseas dividends, and that what is happening is that there's a tax charge on the foreign source dividends that's in effect being postponed to a later year. And so when we get to FII Supreme Court 3, which is still in volume 4, but this time tab 37, starting at page 1312, the argument moves on, and I hope what I'm about to say will answer the question that Lady Justice Falk raised with me about what the solution is, because the Supreme Court then is going to tell us what do these requirements of EU law actually mean in terms of what we do about remedy. Oh well, I'm sorry. I hope I will deal with it, and if I don't, please do ask me it again. So what we're dealing with is section 7, which starts on page 1374, paragraph 119. And just if it helps for you, Lordship's note, there's a summary of the Supreme Court's reasoning in paragraph 14 of my skeleton, electronic page 314. I wasn't going to read it all out, but it's probably useful to have that to one side as we run through this, and I'll try and take it short.
Sorry, could you give me the page number again?
For the skeleton, of course, it is...
No, not the skeleton, in the judgment.
Oh, I'm very sorry. Authorities, electronic, page 1347 is where the discussion starts. This is the Supreme Court exploring what this further aspect of the lack of equivalent treatment actually means on the ground when it comes to remedying the defective UK system. So the court, having set out the issues and having explained in paragraph 121 in broad terms how the reliefs work, and that's a paragraph I'll come back to under issue 3, it goes through Salonen at 134 to 139. I wasn't going to take you back through that. The conclusion is, and this is at 140, 1353, that on the basis of Salonen, what EU law required was that any unused double taxation relief credits, and those credits, of course, have to be calculated at the higher of the foreign nominal rate and the tax paid. So that's another aspect of the unlawfulness, but a slightly different aspect to the unlawfulness that we're now discussing. Those DTR credits, they must be carried forward for use against any tax liabilities arising in subsequent years. Then at 141, really what does that mean for the remedy is what the court is asking. And the two approaches are set out, and so the claimants are saying we should be carrying forward the credits, and if tax has been paid, then it's a San Giorgio claim, and if not, then the credits remain available. The revenue says, no, what you should do is say that the credits were treated as used and you preserve, for example, the management expenses, so then you can carry forward the management expenses. Paragraph 142, bottom of 1353, that rejects the revenues approach, and that is done as a function of the required conforming construction, because
Sorry, 142.
at 142,
142.
142 is the rejection of the revenues proposed solution. On the
Sorry, Mr. Bremer, it must be very obvious to everybody else in court, but I don't understand why it matters which relief you carry forward.
It doesn't in terms of the numbers. That was why I was saying they're essentially the other side of the two sides of the same coin, certainly numerically.
Why is there an argument then between the claimants who say you carry forward this unused DTR and the revenue who say you carry forward unused management?
It mattered in this case because what the revenue appeared to be seeking to do was to eliminate the claims for group relief, because one of the arguments was to say there was no mechanism for carrying forward group relief. So it mattered.
That's what answers my question.
Yes. So it mattered, but we're not dealing with group relief.
In relation to management expenses, it probably wouldn't have mattered.
Well, numerically, it shouldn't have mattered. It may make a difference as to what claim has to be made, because there is a point that I'm going to come on to about what you might have to do for a statutory claim, which is part of my learned friend's case. And there's a very curious finding in the upper tribunal in the post-prudential litigation, which is going to come up for debate in this court in January.
So it's broadly about the flexibility of use of reliefs. The revenue were arguing that you should be treated as having used the double tax credits, whereas where the Supreme Court got to is no. The losses, management expenses, group relief should be treated as set off against the dividends. That's what's been called stage one.
Yes.
And then what gets carried forward, contrary to what the domestic regime actually allowed, was the double tax.
Yes. And that's quite a robust conforming interpretation, because as my learned friend observed, there wasn't any provision that allowed that to happen. So this is an illustration of the muscularity of the conforming interpretation in action. And it's done really on the basis of an analysis of what is the best fit in the Supreme Court's view between the proposed conforming interpretation and the existing provisions, because you can see that in the final sentence of 142, that it's the DTR legislation which is contrary to EU law. So if you can, that's where you should find the solution. That's what points the Supreme Court that's what the Supreme Court tells us points in the direction of the solution that they endorse. 144 and 145, that gives us in more detail the conforming interpretation. You need to be able to carry forward this DTR. And then at the top of page 1355, so this is the penultimate sentence of 145, the court tells us what the position is looking to the future. Looking to the future, the DTR credits, they must be regarded as remaining available. And they say that's consistent with the treatment of the unutilised lawful ACT in Prudential Para 103. Again, I'm going to come back to that under issue 3 here.
Are we concerned at all in this case with the dispute about whether it's on an FNR basis?
That's all done.
That's all done. FNR means foreign nominal.
Foreign nominal rate, yes.
And so if there's a 30% tax rate in the foreign country, that's the rate you use, even if the effective rate is less.
Yes, capped at the UK rate. So if the UK rate was say 28, you get 28 rather than 30 in your lordship's example. But the point about the foreign nominal rate is that the UK did not give enough credit, and that was what we argued out in the prudential test case and also in FII, how much more credit needed to be given. We're now
Where is that debate finally resolved?
it is finally resolved in Prudential Supreme Court and then by this court in FII Court of Appeal. Prudential Supreme Court tells us that it was the foreign nominal rate credit for portfolio dividends. FII Court of Appeal 2 in 2016 says it's the higher of the tax actually paid overseas and the FNR credit. The Supreme Court in FI refused permission to appeal against that ruling. I'm afraid I don't have the paragraph numbers in my head. If it matters, I can give them to you. There was a lot of debate, as your lordship will appreciate, about exactly what was involved there. But that question is settled. So that question of how much credit was required to be given is no longer up for debate. We're dealing with this
How you do it.
additional aspect of the unlawfulness which was revealed in Salonen. So I've dealt with the point looking to the future, that's para 145, and then 146, the court says, well, okay, what, however, of the situation where tax has already been paid as a result of the inability under domestic law to carry forward unused DTR? And they explain how they are dealing with that. Simply saying, well, you've still got the credits, that doesn't meet the requirement of effective legal protection because the states have got the money. And so we're within the San Giorgio principle, that's the conclusion. And then there was a further debate, which I won't take up time with the detail of. There was a debate about whether that should be classified domestically as a claim in restitution. And that's resolved in the claimant's favour that it is so to be classified in paragraphs 155 to 156. I'm skipping over the various points that were taken about the year 2 liability is lawful. The Supreme Court says, well, no, it's not, because there was unlawfulness in the system in that the DTR couldn't be carried forward. And then they tell us that these are restitutionary claims in 156 by the letter G. They can be Woolwich claims, but they can also be made in mistake of law. There just has to be a mistaken belief as to the lawfulness of the relevant aspects in the tax regime. And then there are various points made by the revenue rejected in 157. And then the court's conclusion is at 158, and I think we've seen this with my learned friend yesterday. And it's a recapitulation. Is put the other way around actually to 145 and 146. They first of all look at what's happened when tax has been paid. You get it back in restitution, and then to the extent that there wasn't a payment of tax, the unused credits are to be regarded as remaining available. So other than the ability to carry forward the DTR, the Supreme Court isn't further moulding these provisions. What they're doing is giving the conforming interpretation, and then they're telling us what the remedial consequences are. And what we're doing essentially is working out how much tax has been unlawfully charged or paid by mistake, and applying that required conforming interpretation. And what's critical to all of this is the lack of equal treatment between the domestic dividends and foreign dividends, and that lack of equal treatment is manifesting itself in the indirect economic double taxation of the overseas dividend income. That's why I say that this is just a further aspect or illustration of the same core unlawfulness of lack of equivalent treatment. And just going back to what was said in Salonen, the reason for that, putting it another way, is because the domestic dividends, they're not subject to the potential for economic double taxation because of the exemption. Contrast the overseas dividends, which will at some point, one doesn't know when, but they will at some point, if there are profits, be subject to economic double taxation. So the judge's example, paragraph 108 in the judgment, that was in the core bundle. The core bundle at page 113, that just puts numbers on a year one, year two illustration. I wasn't going to go to the detail of that. It was based on submissions I made to the judge below. There's no challenge to it in this court. It's a helpful illustration of how this actually works on the ground. And I adopt the judge's summary of what was said in FI Supreme Court 3 and 113. That analysis, I say, is absolutely correct. I've laid it out slightly differently in the oral submissions, but the judge correctly understood what was set out in Supreme Court 3. Now, it so happens, this is just for completeness point, that it appears that even now we may not be quite at the end of the road for potential legal developments in the analysis of these claims. This is the point I make in paragraph 64 in the skeleton at page 332. And I don't want to make a meal out of this, but it is worth the observation that before the judge, there was a point made by the revenue that actually, on the basis of the judgment, the claims must have accrued when the dividends were received. We quote from some submissions that the revenue made to the judge in the post-judgment phase when there was argument about the order.
Just so I'm clear though, isn't the revenue effectively challenging that conclusion?
Well, it's quite
on this appeal.
It's quite hard to see. Well, there is potentially a problem, of course, because if the limitation period was running and claims accrued when the dividends are received, it's very difficult to see how the revenue can get anywhere at all on their submissions on ouster in particular, and also a lot of the submissions on pleading. That's why I say that there is an inconsistency in the way that the revenue's putting their case. Because if there were merit in this, pleading and ouster would be irrelevant, because the cause of action would, on the revenue's own case, quoting, it accrued when the dividends are received. As I said, I don't want to make a meal out of it, but what the revenue does seem to be doing is trying to have it both ways.
Presumably, that submission was post-judgment and simply saying, if you are right, then it follows. We're challenging whether you're right, so in this court, they're saying the judge was wrong. So.
Well, maybe, in which case the point may go away, but it does appear that they're trying to say you are ousted. However, if you're not ousted, you're then time-barred. It is quite odd.
It's just working out the consequences of the judge's judgment.
Well, it seems to be more to it than that. But as I said, I don't want to make a meal out of the point. What I do want to focus on is what claim was actually made in this case, and what do the pleadings that were served in this case actually show, because that's what I need to deal with in order to make good the submission that we have an effective claim which allows AXA to recover tax unlawfully charged in the circumstances that have been established in Supreme Court 3. So that's what I'm going to do now by reference to the 03 pleadings and 09 pleadings in particular, and I'll also touch on 2019. So I shouldn't need the authorities anymore. I will in a moment need the supplementary bundle. My submission is that what happened here is that AXA, going all the way back to 2003, it challenged the lawfulness of the UK system. Part of what it asked for, and I'll show the court this, was a declaration that it wasn't chargeable to UK corporation tax in respect of the overseas dividends. And also, it asked for restitution of the monies paid or liable to be paid in consequence of that unlawfulness. And that has been part of the claim ever since it was first issued in April 2003. I say that that is more than sufficient to assert a restitution claim which enables the recovery of the tax ultimately overpaid in 2017. And if I'm right in that submission, that claim plainly was made before the ouster in paragraph 51 sub 6 came into effect. As I say, I'm going to focus on the pleadings as they stood before the ouster was introduced in 2010. The substance of the passages that I'll show you, that's still reflected in the 2019 iteration of the claim form and the particulars of claim. And my position on the 2019 pleadings is that what is being done there is they're providing further particulars of claims that have already been made. That's what I say is happening in 2019. Now, there are, of course, other versions of the claim form particulars of claim. They were amended at various different times, but we've put in the bundle for this court the ones we think that are most relevant, and nothing we don't think turns on the other ones. So, starting with 2003, Supplementary Bundle Tab 1, page 3. As I've said, there's a challenge to the lawfulness of the UK dividend tax provisions. There's a restitution claim for monies paid or liable to be paid as a result of that unlawfulness. In the brief details of the claim on page 3, paragraph 1 seeks declarations in relation to 208 and then section 18, Schedule D, Case 5. That's later changed to include Case 1. We'll see that in the 2009 iteration of the claim form. And its unlawfulness on the basis of breach of EU law. And of course, it's 208 and Schedule D Case 5, also Schedule D Case 1, which are what gives rise to the fundamental problem, which is that the UK is operating its exemption system for domestic dividends, but a credit system for foreign dividends, which failed to grant equivalent treatment. And in paragraph 2, still in the brief details of claim on page 3, that's the claim, among other things, for restitution of monies paid or liable to be paid.
If you haven't paid, there's no enrichment, is
I'm
there?
going to deal with that, Lord. There's no well, a claim was made for the return of the money paid or to be paid, and I'll deal with this point about a future claim. But once I've shown you, Lordship, the pleadings, if I may, because in my submission that isn't an answer. Now, from Mr. Wilmot-Smith's put it at the heart of his case on the appeal, it's not an answer to what was actually claimed.
I've got a different question, which I'm not sure arises on this issue, but it's been puzzling me, which is, if you've got a mistake-based claim, the claim has to be, I mistakenly thought these provisions were lawful. Yeah, that's how the mistake-based claim works.
Yeah.
If you issue a claim form 2003 saying these provisions are unlawful, how can you say in 2017 when you make a payment, I was suffering under a mistake?
Yeah. That question doesn't arise in my respectful submission because I get home under unlawful demand in Woolwich. I don't need a mistake-based claim in respect of 2017.
Oh, I see.
So your Lordship may well be right, but it doesn't arise in this case because Woolwich is good enough. Particulars of claim, they're set out actually within the claim form, so on page 4 and following. And we looked at some of this with my learned friend. Paragraphs 3 and 4 are making the point that there's differential treatment in that domestic dividends wouldn't have been chargeable to corporation tax, whereas overseas dividends were chargeable. And we know from Salonen that it's that indirect economic double taxation of the dividend income that is this further aspect of the discriminatory treatment. And it's a further aspect that arises actually from having one system for domestic dividends and exemption, and then a different system for overseas dividends. And then 7b, and again we've looked at this page 5, what's sought is a declaration that the claimants are not chargeable to corporation tax in respect of the dividends, and I'd underline in respect of. And again, it's the point about monies paid or liable to be paid, and I am going to come to Lord Justice Lewison's question once I get to the end of the pleadings. And it's in the circumstances referred to in paragraph 3 above. Now, on any fair reading of the particulars, those circumstances are the differential treatment of the domestic source dividends on the one hand and the foreign source dividends on the other. You can see that in particular in paragraph 4, line 2, because the complaint is about the company being discriminated against and or treated unequally. Now, the revenue seeks to say, well, this is all limited to a complaint about the existence of an immediate tax charge on the dividend income. And the learned friend relied on the reference to an immediate tax charge in paragraph 3 yesterday. That doesn't work as a sustainable reading on these particulars. First of all, as things have turned out, the claimants were absolutely right that there was an immediate charge to corporation tax. The overseas dividend income was chargeable to corporation tax in the year in which it was received, but of course chargeability and payment are not the same thing. The problem that's identified in paragraph 3, if one reads paragraph 3 as a whole, is that the dividends should not have been chargeable to corporation tax. That's the second sentence. Yes.
The effect of SC3 is to say, as I understand it, correct me if I'm wrong, that there wasn't a problem with the chargeability in year 1, which led to the lawful offset of losses, because we're looking at not equal treatment, but equivalent treatment. So the immediate chargeability and offset with losses was not a problem, just as if there hadn't been losses, but there had been adequate ETR, that wouldn't have been a problem either. The problem is the tax charge in later years. So I'm not sure I agree with what you've just said.
What I would say about that, my lady, is that the tax charge in later years, and this is why I showed the court Salonen, the tax charge in later years, although in form, the taxation on other income, what it is in substance and in the eyes of EU law, and this is what matters here, because we're talking about breach of EU law, it's the indirect taxation of the original dividend income.
But but does that fit within the concept of for what it's worth, an immediate tax charge?
It does, because because it's the immediate tax charge which leads to the reliefs being used up, and which then means that you have this problem going forward. Because if one looks at the comparison that's revealed in Salonen, the domestic dividends, they're not chargeable at all.
But aren't you mixing up breach of EU law on the one hand and domestic remedy for that breach on the other?
Well, my lord, no. At the moment, I'm trying to pin down what the unlawfulness is, and looking at the complaint about the nature of the unlawfulness. I haven't got to the remedy yet. So I respectfully say no, I'm not.
Right.
I appreciate that one needs to distinguish the two things, but at this stage, I'm looking to identify what is the nature of the unlawfulness. The other observation, I don't want to get too bogged down in immediate tax charge in paragraph 3, because the other point, of course, is that by 2009, which I'm just about to show you, that wording's gone. So my position is it doesn't matter, because actually, on a fair reading of the particulars, what they're complaining about is chargeability generally, and that is apt to include indirect double taxation that comes later in a different form. But anyway, when we get on to 2009, the claim, if that were to have limited the claim somehow, that limitation's not there. So 2009, claim forms on page 7. The basic claim for declarations that the dividend provisions are contrary to the treaty, that's still there. And then again, paragraph 3, it's claims for restitution of monies paid or liable to be paid, reliefs used, etc. Turning now to the particulars of claim, they start on page 9. Paragraph 2, bottom of page 9, that's now including the identification of accounting periods, including but not limited to. So one assumes that this was inspired by what had happened in DMG and by a desire to keep the claim as broad as possible. The basic complaint about discriminations in paragraph 3 the focus on discrimination that's underlined when you get to paragraphs 9 to 10 and importantly, in the final sentence of paragraph 9, the complaint is that what the UK system is doing, because there isn't exemption, is it produces a situation leading to a higher net tax burden on foreign source dividends. And that's why I was tying this in to what was ultimately established in Salonen, particularly I think it's 158 to 160. That was what the Court of Justice saw as the vice in that carry forward situation, was that there was a higher tax burden for the overseas dividends. There's then a claim in relation to the to unlawful demand, paragraph 12.
That's the Woolwich claim.
That's the Woolwich claim, and it's the dividend provisions, but as part and parcel of the UK tax regime. So one can't say, well, the dividend provisions and DTR, it's something different. I'd say that wouldn't be a good point anyway, but this is looking at the UK regime generally. And then mistakes are identified in 13, and that's in paying the tax, and it's in the use of reliefs. And the use of reliefs, the relevant paragraph is 14. 15 is dealing with capital allowances, that's not relevant anymore, but 14 is about use of reliefs. I don't need the paragraphs on AC.
Just pausing with 14.
Yes.
Given, as we now know the rules to be,
Yes.
the use of the reliefs in 14, that's referred to in 14, isn't by itself inoffensive, is it?
No, that's right, but it's the use of reliefs in combination with the inability to carry forward the DTR. That's right. DTR.
But going back to 13B, the mistake is said to be the use of the reliefs.
Well, one could easily say the use of the reliefs includes not using them, my lady. As it happens, I don't need the mistake claim for the 2018-2019 payments.
Okay, but we're not just having this debate, are we, in relation
No,
to
we're not.
2018, 2019? It relates to some the pleading issue is relevant to some earlier periods as well.
It is, and on the basis, I think I'm right in saying this, I'll check, and I'm sure I'll be corrected if I'm wrong, on the basis that the judge decided issue C, all of the claims to which this issue relates are within 6 years. There's an alternative argument I'm running, which would mean that the extended time limit would be needed. But on the basis that the judge decided the case, I think I'm right in saying that the first unlawful payment is 1997, which is within 6 years anyway.
I'm simply focusing on the pleading issue at the moment, not
No,
time limits.
I understand. But I'm just trying to cut to what's relevant in practice for these parties. I'm reminded there's £1,000 on the judge's ruling that is outside 6 years. So I wasn't quite right, but I was almost right. If one's looking at the mistake, there's no difficulty in my submission in saying that the use of the reliefs is capable of including not using them. There is a real danger, I'm going to come on to develop this point, but it was very striking listening to my own friend Mr. Wilmot-Smith's attempts to construe the pleadings and really to read them down. The main merit of the construction seemed to be to seek to eliminate as much of the claim as possible. What I would say is one has to look at this document in the context where we're dealing with claims, which, as the Supreme Court tells us in FI Supreme Court 3, they're at the frontiers of legal development. And it cannot be right that a litigant has to predict the precise basis upon which a domestic court might ultimately arrive at a conforming construction of the UK provisions. The question is, has a claim fairly been asserted and has fair notice been given? We shouldn't, in my submission, be approaching this on the basis that the pleading is to be construed as one might a statute. One has to ask, what is it that's actually being asserted, and have claims been made or have they not? And so I do say, looking also at the way in which this develops, that there's a perfectly sensible construction, even of paragraph 13, which is capable of encompassing a situation where it later emerges that DTR should have been available. It wasn't understood to be available, therefore it wasn't used, and that's the mistake. It's pleaded in sufficiently general terms to cover it. As I said, I don't need that, because as I said to my Lord Justice Nugee, other than the £1,000, we would get home on the Woolwich claim anyway. I said I could skip over ACT, which is 16 to 19, and obviously sufficiently serious breach in paragraph 20 has gone. 21 is worth noting, however. One sees again there the complaint is that the obligations imposed on the claimants to pay tax upon the dividends referred to in paragraph 2. Now, those dividends referred to in paragraph 2, that's all dividends received in accounting periods from 1974. That's what's said to be contrary to EU law. And the court has my submission that the objection that's made by the revenue that the year 2 tax charge formally is a tax on other income, not on dividend income. That is just that. It's a formalistic objection. We know what the basis of the unlawfulness is. There only is unlawfulness because what that year 2 charge is doing is it is indirectly taxing the original dividend income. Then one has the prayer for relief, 23. Little a is a declaration focusing on the dividend provisions, but then more importantly, little b is seeking a declaration that the claimants are not chargeable to corporation tax in respect of the dividends that are being referred to. And that's a declaration, certainly at least in a modified form, to which the claimants absolutely should be entitled, because they're not chargeable to tax in respect of the dividends, to the extent that sufficient credit wasn't given, and to the extent that it's not possible to carry forward the DTR. So that's the declaration aspect. And again, it's the same old point. What is sought is restitution, among other things, of monies paid or liable to be paid. They also want reliefs used, etc., and that's put in terms both of mistake of law and demands, such demands being contrary to the articles of the treaty. And then there's a reiteration of the restitution aspect in 23 little e.
Is there any difference between 23B and?
Not in substance, my lord, no. For the purposes of this argument, I'm not saying I get anything extra from one and not the other.
Can you have, I know this is constrained like a statute, but can you have restitution of reliefs used? That sounds like I used a relief, I shouldn't have had to, and I have to relieve it back.
Well, that would be more apt or more easily relatable to the constructs that were being debated in FI Court of Appeal 1.
But I thought one of the many authorities we looked at said that restitution in English law, you can't have restitution of a relief. You can only have restitution of payments.
And that's why I'm focusing on monies paid or
Yes.
liable to be paid.
Yes.
But if you get a declaration that you're not chargeable, suppose the court makes a declaration, you simply wouldn't pay.
That's right. That's right.
So-
What your lordship identifies there is a point about timing. So suppose the trial had happened at a time when the reliefs are being carried forward. The remedy would be the declaration that you're not chargeable. Paragraph, I think it's 145 in FI Supreme Court 3. What I'm saying is if the trial happens at a time when the payments have been made, then the remedy is different. It's the restitution of the money, paragraph 146 in FI Supreme Court 3. That isn't a difficulty that is created for the pleading. That's simply a function of what is the appropriate response in the light of what's been established to be the claimant's entitlement at the time that the adjudication happened. I wasn't going to show the court the detail of the 2019 claim for more particulars unless you want me to. I don't think there's any dispute that what they do is contain further particulars which set out the legal analysis. That's both in the amended particulars of claim, in particular paragraph 32, which the judge sets out at paragraph 118 of his judgment. There is also paragraph 3 of the reply to the amended defence, which is page 155 in the core bundle, which contains further description of the legal analysis. And that paragraph in particular founds on what has been decided in Salonen and FISC3. What I say is that what's being done in 2019 is simply the provision of further particulars about what the legal analysis is. What it isn't is the introduction of new claims not already foreshadowed and not already covered by the pleadings as they previously stood. Now, I recognise that to persuade your lordships of that point, I need to focus on what was said in 2009. It's not much good trying to construe what was done in 2009 by reference to what was later said in 2019. But I do say that that's the answer to what is actually going on here and to what is happening in 2019. So the claim to recover monies paid or liable to be paid because of the unlawfulness in EU law terms of the UK system, that had been made by at the latest 2009. And as I say, what the 2019 documents are doing is just providing further particulars of that claim. And we saw in particular in the 2009 documents that what's being sought is a declaration of non-chargeability in respect of the dividends. And we know, this was particularly FIISC 3157, that what is unlawful is the indirect double taxation of the overseas dividend income. And in my submission, that reference to tax liable to be paid, that identifies payments of tax liabilities to be incurred. Yes, of course, in the future. Of course, I accept that. But it identifies those payments. It's the future tax liabilities to be incurred which arise because of the unlawfulness identified, the unlawfulness being the lack of equivalent treatment. And that is apt to cover a circumstance where there is, in the later year, in year 2, in the judge's example, unlawful indirect taxation of that dividend income. That's why the judge was absolutely right in paragraph 125 in his judgment when he concluded that the claim that was recognised in FIISC 3, that was in effect a claim for restitution of tax overpaid on the overseas dividends themselves. Now, my friend Mr. Wilmot-Smith submitted, well, in effect, that gives the game away. When you say in effect, that means that's not what it is. No, you can't say that, having regard to the reasons articulated by the Court of Justice in Salonen and in FIISC 3. We know that the problem here is the unlawful indirect economic double taxation of the original overseas dividend income. And that's why I say, going back to the judge's example, the charge that arises in year 2, yes, of course, in form, it's a tax charge on other income, but the reason it arises is because of the over-taxation of the original dividend income. So in the year 1, year 2 example, dividend income in year 1 is indirectly and unlawfully taxed in year 2. Now, if I can turn to the points that are taken against me on the pleading, and I've touched on the first one already, which is in the revenue skeleton at paragraph 25. This is the point about tax paid immediately on the dividend income. My learned friend says, well, what was claimed in the pleading was tax immediately paid. The FIISC 3 claim, that's a different kind of claim. It's not a claim for tax on dividend income at all. And he packaged that up in his oral submissions as his stage 1, stage 2 analysis yesterday. And as we explain in the skeleton, that's wrong for at least 2 reasons. First of all, and this is the point in paragraph 26, it's the point I've made several times already, it ignores that the basis of the claim is seeking restitution for unlawful indirect double taxation of the original income. It's a partial account of the claim to say it's for restitution of corporation tax paid on other income. There's no problem in EU law terms with charging corporation tax on other income. This claim only arises because that charge, which is in form on other income, in substance and reality, is actually overtaxing the original dividend income. That's why we're here. That's why we won. I say why we won, why the claimants won in FIISC 3. The second answer, and the second reason why the revenue can't be right in that complaint, is that what's being claimed is restitution of the monies paid or to be paid in respect of the dividends. That must be right when you read the claim for the declaration, which is expressly put in terms of not chargeable in respect of the dividends.
Just going back to your first point,
Yeah.
let me assume, for the sake of argument, that the discrimination and therefore the unlawful treatment is broad terms, overtaxation of the dividend, the effect of that discrimination is not felt on your example until year 2, is it?
Yes, that's correct.
So it's only in year 2 that you've got a claim, isn't it?
That's correct, and that doesn't give me a problem. I don't have any difficulty with that, because what I'll be submitting is we've sufficiently identified the payments, we've sufficiently identified at the expense of, because it's AXA that made the payment, we've sufficiently identified the unjust factor, because the revenue knows it's Woolwich and it's mistake, and both of those are founded on the unlawfulness in EU law terms of the UK tax system. The fact that the claim is only arising in year 2, that is what was fatal in FII Court of Appeal 1 in 2010. If one reads through paragraph 180 to 183, that's the critical stumbling block, because it means either there's no proper enrichment in year 1, or alternatively the charge in year 2 is lawful. So one way or another the claims fall flat on their face. We now need a more sophisticated analysis that recognises that what the year 2 tax charge is the culmination of an unlawfulness that begins in year 1. Now, going back to the requirements in terms of pleading, what's required, and this is in 16.4 sub 1 sub A in the CPR, is a concise statement of the facts on which the claimant relies. And that's at authorities page 141, just for the courts. I'm sure the court's more than familiar with the requirements. My submission is that the pleadings that I've shown the court meet those requirements. The pleadings identify corporation tax paid, but also tax liable to be paid by AXA to the revenue in respect of dividends received from overseas companies. And I do say that is an identification of facts which fulfill enrichment and at the expense of. And it's not an answer from a learned friend to say, oh, well, that's in the future. The question is, have I identified the payments at this stage? Yes, I have. I say I. Has AXA identified the payments? Yes, AXA have identified the payments. And it's articulated a case that it shouldn't have been chargeable to corporation tax in respect of the dividends, and that in consequence, there are or there will be unlawful demands and or payments by mistake, and which must be reversed. And that, in my submission, goes to and fulfills the unjust requirement.
It might be the case that there will never be tax.
That's true.
What happens then?
In that case, the court would be making a declaration that the reliefs are still available.
That's why I have difficulty in fitting it into a restitutionary claim. Because there may never, as my lady says, there may never be any.
No, but there are different forms of relief are claimed. What relief is ultimately given by the court will need to be determined by reference to the facts as they're established at trial. And you can see in the Supreme Court's judgment in FII Supreme Court 3, 145 and 146, the very clear recognition of the two possibilities. It may be that tax has not yet been paid, in which case you still have the reliefs available, and in my submission you'd be entitled to the declaration,
Yeah.
or you have paid, in which case you should get the money.
But the Supreme Court is not addressing this issue on which we're focusing, which is not so much what relief might you be entitled to, but what and when did you claim it?
That is true, although it is worth noting, as we say in the skeleton, that the pleadings of the BAT claimants, they are in exactly the same form as the ones that are relied upon by AXA. And no such difficulty as is now being argued about was identified. One might if this was a serious point, one might have expected the Supreme Court to have had something to say about it. The pleadings were before the Supreme Court. There was no point taken by the revenue. I fully accept that.
Well, that's the problem with this litigation. It's a bit like whack-a-mole. As soon as you put one point to bed, another one pops up.
So can I be sure I understand it? Looking at your 23B in 2009,
Yeah.
the declaration that the claimants are not charging corporation tax in respect to dividends, you say that's wide enough to say we should not have paid tax in year 2.
Yes, it is. It is.
Because in economic terms, although not in legal terms, that is corporation tax in respect to the dividends received in year 1.
Yes,
That's
exactly.
your
That's exactly right.
I'm finding it difficult to keep in mind two quite different things, which is that you're facing an argument that on the one hand you just haven't pleaded the year 2 payments, and you can't plead year 2 payments which you haven't yet met.
Yes.
And they're quite different analytically.
They are two different arguments. That's right. And I am going to address directly the point about you just can't do this. I am going to come on and do that. The first point, I do say the answer lies in a proper understanding of the nature of the unlawfulness, because corporation tax. It may be corporation tax on trading income as a matter of the purely domestic application of the UK taxing provisions, but one can't avoid looking at why it is that that corporation tax has arisen, and one can't avoid the reasoning of the Court of Justice in Salonen that the problem actually is because that charge, although in form, a year 2 charge on something else, actually what it is a deferred charge on the original dividend income.
In economic terms. I mean, they're quite clear to draw a distinction in economic terms, economic double taxation and juridical double taxation.
Yes, one has to be a little bit careful because juridical double taxation has its own very particular meaning of but yes, they are focused on the economic analysis in Salonen. That's right, and I've previously talked about in substance rather than in form, but I don't have any objection to in economic terms, in legal terms. The other point I just need to deal with is the attempt in the revenue skeleton at paragraph 28 to say that somehow the schedule limits the relief that's sought. We explain why that doesn't work in paragraph 28 of the skeleton. There are 2 points in particular. Those words without limitation, they're repeatedly used in paragraph 2 of the 09 particulars in relation to the schedule, so it clearly isn't trying to limit the claim. It's also the case that when you look at the detail of the schedule, it simply can't be the case that the schedule is only covering in-year tax liabilities. The reason for that is that actually even the amounts that are on the face of the schedule, they are bigger than the known in-year tax liabilities. I can't show the court a document in the bundle that makes that good, but the point we make in the skeleton I don't understand to be disputed. And actually it's even more obvious than that because the dates in the schedule relate to years in which AXA was not tax-paying at all. So they're claiming for years where there were no immediate tax charges, even if one were to adopt the revenues analysis of that concept. And then the fourth way in which the revenue is putting its case in the skeleton, and this is the last point I'll deal with before coming on to the point about futurity. This was paragraph 29 of the skeleton, was to look at this at a much more granular level, to say, well, what you needed to do was plead foreign dividend income against which management expenses had been set off. You then needed to plead the other income in the subsequent period. And I repeat the point I've already made. What we need is a pleading of the enrichment at AXA's expense and of the unjust factor. What one can't, after the event, impose yet further requirements about what has to be set out about the specific legal analysis of the claim. And the court has my submission that what has been set out in the claim form and the particulars is sufficient. It's also relevant. My friend took the court to what Lord Burrows had said in the Samsundar case. The one point that I wanted to remind the court of in relation to Samsundar, which is Authorities Volume 3, tab 35, starting at 1168. He is talking between letter E and F about the ideal pleading. He isn't trying to set out minimum requirements. It is true that in Samsundar itself, the appeal fails because they hadn't identified a mistake. That ultimately is decided on the basis of the lack of fair notice in the Trinidadian limbs of the proceedings. Here, of course, the revenues had all the particulars because they've had the additional material in 2019. They certainly can't say by the time the preliminary issues are being tried that they don't know what the case is. The question is, was sufficient done, in particular prior to the ouster, that what is happening in 2019 is the additional particularisation of an existing claim that's already been made, or is it a new claim? And I do say that Samsundar, and particularly the outcome in Samsundar, is of very limited assistance in answering that question. Now, fifthly, and I think finally, in terms of the objections, I'm just going to say something very brief about DMG once I've dealt with this. The fifth point is to deal with the point about futurity, which is engaging with the question my Lord Justice Lewison put to me a short while ago. And it picks up on the submission my friend Mr. Wilmot Smith made yesterday, day 2, page 82. The way he put it was, you can't plead a future fact. And the other way he put it was to say you can't have restitution of a liability. My respectful answer to that is that that is an exercise in semantics which doesn't read down the claim that was actually made. It is noteworthy that my friend offered no authority for his proposition that one can't plead a future fact. He candidly said that he hadn't identified any. What he tried to do was to make it my problem. He said, well, there aren't any examples of this actually happening. It isn't my problem with respect to the revenue. The question is whether AXA identified facts which will support a claim in restitution. And what it has done, it has identified payments of tax. They are the payments of tax that arose in respect of the dividends, both past and future. There was no challenge at the time it was made to that pleading. There was no request for further particulars. There was no application to strike it out or anything like that. As I've explained, the analysis of the invalidity of the UK system, it gave rise to various different possibilities, and we saw the development of the various answers as time went on. And I do say that particularly against that background of a developing legal analysis, there isn't any difficulty in making a claim, as indeed was made, for recovery of monies paid or liable to be paid. I said earlier, had the money not been paid over by the time of the trial, then no doubt the relief granted would have been different. If the trial had been happening prior to FII High Court 1, I suppose AXA would still have had its argument that it was entitled to restitution in respect of the reliefs valued on a loss of chance basis. And if the court had taken the same view as Mr. Justice Henderson, the Court of Appeal, that claim at that time would have been rejected. AXA might or might not have been entitled to its declaration. It still had the double taxation relief. That there was a time when that was viewed, as we saw in the Court of Appeal, as a matter for the statutory procedure. Subsequent developments have shown that the statutory procedure wasn't exclusive. None of that helps in answering the question whether the necessary claim has been asserted, because what you've got to ask is, has AXA actually identified payments of tax? Has it identified the unjust factor in particular? And it's done those things. That's why I say the
confess, I do have some difficulty in that you referring to identifying the payments of tax. If the tax hasn't actually been paid, you have no idea, for example, as to its amount, because the value, if credits are carried forward, you don't know what the values are and when it's going to be paid. Whether
you weren't at the time, my lady, but that's a matter that goes to particulars. It doesn't go to whether the claim has been made or not. My friend has to go so far as to say that it was impossible for a valid claim to be made at that time. That's how far the revenue has to go.
Can I step back from this for a moment? Correct me if I'm wrong, but I think the reason that we are asking this question at all is to decide whether the ouster provision applies.
Well, we're asking it at two stages because, as I understand it, the revenue disputes that any claim has been pleaded for the reliefs at all. But yes, principally we're interested in whether the ouster provision applies.
And the ouster provision talks about a claim for money or a claim to discharge an assessment.
Right. I need to deal with that head on because
if you haven't claimed, for money, if you haven't claimed for repayment of money paid or discharge of an assessment, then aren't you caught by paragraph 51?
No, and I need to explain why. But I was going to do that under the ouster.
All right.
The snapshot is that what your lordship is describing is the statutory claim that was brought in with effect from 1 April 2010. That cannot tell you whether a valid claim was made prior to that date under requirements which ex hypothesi had not been enacted. So I'll develop that. But that shortcut to deciding the ouster issue, it simply doesn't work in my respectful submission.
Can I put it this slightly different way? If one stands back, we have, if you want to claim money from someone using a claim form, you have to have a cause of action against them, whether it's debt or damages or restitution or whatever. Normally, if you want to claim money from someone, you have to plead all the facts which make the money due. So if it's debt, you have to plead the contract, the obligation to pay, and the non-payment. If it's damages, you have to plead the tort and damage and so on. What is wrong with a simple proposition? If you want to claim money from someone by way of unjust enrichment, you have to plead the payment which has enriched them. And as I understood Mr. Wilmot-Smith, in relation to the futurity point, the 2017 point, he said it is indeed impossible in 2003 to plead, or in 2009, that I paid you money in 2017 and I want it back. And it's no answer to that to say, I can plead a claim for a declaration which says if I pay you money in the future because of all these unlawful statutory provisions, then I will ask for it back on the basis it's all unlawful. Because that's not the claim which you're now pursuing. What you're now pursuing is a claim saying, I want judgment for X pounds. And in order to get judgment for X pounds, you need to plead that you've paid X pounds, and you need to say, that's the payment which enriched you. As I understood him, what he was saying was very simple, which is, you can't say, I have enriched you if you haven't yet made the payment. That's what I'm struggling with
And
at the moment.
can I try and help with that? Because I do say that confuses two different questions. What claim has been pleaded, and what's the appropriate relief at different points in time? Because my starting point is to say, particularly in the light of the uncertainty that existed, and in the light of the various potential analyses that might apply, there was nothing wrong or eccentric in saying, actually, certainly by 2009, we might have overpaid already because the reliefs have already been used up. If that had been right in law, that would have grounded a successful claim. And you can't beat that by saying, well, okay, that claim fails in law, but actually on a basis that means that payments that have since been made and before the trial, they were unlawful, and we know we shouldn't have had them, but oh, terribly sorry, we say you didn't plead them. Because what one needs to ask, suppose my friend Mr. Wilmot-Smith is right, and there is some problem with what has actually been pleaded. One does have to deal with what are the consequences. It doesn't follow from anything that the revenue has submitted that no claim was pleaded. At the very most, what it might mean is that the revenue might have been able to ask the court to strike out that part of the pleading under either inherent jurisdiction or CPR Part 3.4. That was never done. Instead, what we're faced with is a situation where the pleading has been sitting there in its form as set out in 2003 till 2009, where there is, as I said yesterday, no substantive debate, because I'm characterising the ouster objection as a procedural objection. There's no substantive debate about AXA's entitlement, where AXA has identified the money that it wants. And what the revenue seems to be saying is, well, I'm terribly sorry, your claim in 2009 was premature, because if you'd had a trial in 2009, the judge wouldn't have been able to give you that relief. But that wrongly, in my submission, seeks to override the fact that AXA has brought this claim to assert its EU law rights. It has said, give us back the money either that we have already paid or that we will have to pay you in the future. It's identified that money, at least at a general level. I absolutely accept what my Lady Justice Falk says to me. We don't know whether ultimately there will be tax. We don't know in which year. Further particulars, as it happens, were provided. My point is that when the further particulars are provided, they are just that. They are further particulars of a claim that has already been made. That's why I say that on this issue, the revenue is confusing. The question of what has been pleaded, what claim has been made, and what is the appropriate relief at different points in time. And I do say that that analysis, it's consistent with what's been held in the authorities, particularly DMG, which we've looked at, and I wasn't proposing to take the court back to it. It'll come as no surprise that I rely on what was said by Lord Justice Jonathan Parker, paragraph 247, about the possibility of the pleading being complained about as embarrassing, but actually the way of dealing with it was through particulars. And Lord Justice Rick's observation at paragraph 257 that he'd be reluctant to hold that a claim form which sufficiently identified the cause or causes of action sued upon would fail in its purpose because of some lack of particularity. It's lack of particularity that we're dealing with here. It's not that there was a failure to make clear that it's restitution, it's wage, it's mistake, it's these payments of tax that relate to these dividends. Can I deal then with the ouster issue?
Yeah.
I support the judge's conclusion in paragraph 131 of his judgment that the ouster doesn't apply. Questions the court will be well aware is whether AXA's claim was made prior to the 1st of April 2010, and that, of course, is the commencement provision in section 100 sub 2, Finance Act 09. And my submission is simply this, that the claim was made on the 8th of April 2003, alternatively, when the second amended claim form and particulars were filed on the 20th of July 2009, and if I'm right in that, we're before 1 April 2010 and the ouster doesn't apply. key starting point in my submission in dealing with this issue.
And sorry, just before we get there, I did ask this, I think I may have asked this yesterday. Is it straightforward to tell how this issue relates to the pleading issue in the sense of, I know both would cover the 2018 and 19 payments, but as I understand it, the pleading issue covers more tax from earlier years than the issue we're talking about now.
So
Can you, at some stage, someone point us to what the difference is? What are the years are in play for the pleading
right,
issue?
I'll try to do that. I might just
think we were shown a schedule which I can't now lay my
yes,
hand
I was just trying to remember where it was.
on. Yes, I can't see it now.
It's presumably in your 2019 pleadings.
Well, that's what I was just.
Yeah, I looked there, but I didn't immediately recognise it.
Is it in the statement of case? It may be in the statement of case for the preliminary issues hearing. Yes, that's probably the most convenient place. At electronic 190, and I think we'll go away and check this if I may. But can I give a provisional answer, which I think should be correct? The pleading issue, certainly the way my friend puts this sort of macro pleading point, that you've never identified a claim of this nature, so his stage 1, stage 2 analysis, the revenue looks to attack all of the years in which unlawful tax was paid.
Okay, I mean,
Those figures, of course, include.
so I know you told us it includes other tax.
Yeah.
The reason I'm asking, I'm just thinking aloud, is that to the extent this is relevant to the periods between 1995 and 1998, those tax payments had presumably
Had been made.
before
Precisely.
before the claim was issued.
That's right.
And before the claim was last
That's
relevantly amended in 2009.
That's right. That's why I answered when I said my friend's macro way of putting his pleading point. As I understand it, the revenue is trying to say that this type of claim was never made, therefore there's no pleading on anything. I say that just can't be right, because money's paid covers this anyway. My friend's other point is his futurity point, so you just can't do this. The futurity point, as I understand it, is only capable of applying to the payments relating to the 2017 and 2018 accounting periods, which were made in 18 and 19.
So the only argument, as you put it, in relation to those earlier years, can't be futurity. They've already been paid.
I would certainly submit that's right.
Your understanding is that revenue are seeking to say you still didn't plead
Yes.
those amounts because, to the extent they're not actually taxed on dividends.
Yes, and I hope I've explained why I say that that submission's
thank
wrong.
you.
But
Just picking up on that,
of course,
if the revenue are right that you didn't plead the 1995-1996 claims because you only pleaded year 1 claims, you didn't plead year 2 claims, which is their overarching.
Yeah.
Does that mean that the ouster argument also ousts those claims? Because you've brought them in now.
yes, that's right.
But you've brought them in 2019, and that's too late. You accept that if you didn't plead them by 2009, it's too late to bring them in later.
If I hadn't made a claim before 1 April 2010, then the ouster bites, subject to one observation that I'll make in a moment. Now, dealing with the ouster, critical starting point is that the unlawfulness in the UK system, it includes the denial of the ability to carry forward the DTR. And that is an unlawfulness present in the UK system from the moment that the dividends were received. And so the taxpayer is, if you like, locked into a subsequent unlawful tax charge which will arise when he next becomes profit-making. When one looks at what the draftsman has done in section 100 in the commencement provision, that is to identify or ask the question, when is it that the claim was made? And one sees that in Authorities, Volume 1, page 129. And the court has my submission that the relevant claim was made long prior to the ouster coming into effect, either in 03 or in 2009.
Now, I put to Mr. Wilmot-Smith, and I think he agreed that section 100, subsection 2, when it speaks of claims, means claims as described in paragraph 51.
And one needs a much more precise and a slightly fuller response to that question in my respectful submission, because what my learned friend I think was seeking to draw out of section 100 sub 2 was that you needed to identify a claim that was like or had factual features that were like the ones identified in paragraph 51, 1A and B, so amount of tax paid. Or liable to pay an amount of tax and you're asking for discharge. So I mean, I'm looking at the version that's at page 87. And it was being said, well, that shows you that it was to try and reinforce the futurity points, to say, well, you can't make a claim until you've actually paid the money. I need to explain why that doesn't work. The reason it doesn't work is that what paragraph 51 is doing is introducing a new statutory procedure. Paragraph 51 is going to be the new mechanism having effect from 1 April 2010, which is going to be used to reclaim tax from the revenue. It does not follow that the commencement provision is to be interpreted as meaning that there can only be a claim made in respect of monies already paid out. Because what one would be looking at is actions that have been taken in the past prior, actually in this case, both to the enactment of para 51, but also, more importantly, prior to its commencement date. And whether a claim has been made or not, that needs to be looked at, but by reference to the rules as they were applicable to claims made at that time. One doesn't say that there's a new procedure introduced with effect from the 1st of April 2010, and that undermines actions that were taken in the past, if those actions were valid.
Well, would you accept that this is a question of statutory interpretation?
Yes, I do. One has to construe section 100. Yes, of course, that's right. What one is getting out of section 100 is that there's the introduction of a regime which is expressly said to apply in relation to claims made on or after 1 April 2010. Now, those claims for money paid, 51(1)(a), or for discharge of a liability, 51(1)(b), they are the new kind of statutory claims. The ouster is 51 sub 6. So the ouster is saying, you're now getting this ability to make claims. The commissioners aren't liable to give relief except as provided by the schedule or under other provisions. But that doesn't help you with the question, which is the relevant question here, which is whether in the pre-1 April 2010 world has a claim been made. That question in my submission is, yes, it's a question of statutory construction, but it's largely actually a I suppose it's a mixed question of fact and law. What you're asking is what was done at that time by reference
What
to the
claim?
provisions as they were
What
made at the
claim
time.
has been made? If you were to, suppose you were simply to claim a declaration that you're not liable to pay a certain charge, some of which you've paid and some of which you may have to pay in the future.
So
All you claim is a declaration.
So the declaration clearly wouldn't be ousted.
No, but what about the consequences? You get your declaration. Can you say to the court, well, you've made this declaration, now I want my money back?
But it depends whether you'd made the claim prior to 1 April
Well,
2010.
that's what I put to you. You simply claim a declaration.
Well, but my submission is that this is not a case where simply a declaration was claimed. That's why I am saying that the claim was pleaded and therefore made
No, I understand that.
prior to 1 April 2010.
So I think you are saying that the relevant claim for the purposes of Section 100 is a claim for money,
yes,
not simply a claim for a declaration.
yes, that's right. But I'm also saying that the claim for money made prior to 2010 could include a claim for money that would be paid in the future.
That's a futurity point.
And that's the futurity
I follow.
point. And that's why I say that one can't shortcut the question of statutory construction in Section 100 simply by saying the futurity point must be good because of para 51.1a and 51.1b. One can't do that because one has to assess this by reference to the rules that applied for the making of claims at the time that the claims were made. It would be offensive in EU law terms for a claim validly made then subsequently to be knocked out as a result of the ouster. And if I'm right about the pleading, that is the consequence of the revenues case on ouster. And it's also relevant in this context if one's looking at Section 100. The draftsman could easily, had he wanted to, have sought to apply the ouster. This may have given rise to other issues, but he could have applied the ouster by reference to dates upon which payments of tax were made, or he could have done it by reference to particular accounting periods. If one looks, for example, at the statutory time limit, which is 51 capital B sub 1, which you'll get at electronic page 92 in volume 1, claim under para 51 may not be made more than 4 years after the end of the relevant accounting period. Now, the draftsman didn't take that approach.
Wait, what page you just looked at?
Well, this is 51B. It's electronic page page 92.
92.
That's the version, as I understand it, that was in force 2009 to 2011. There are all sorts of changes to these provisions at different times. I don't think any of the changes affect this one. The draftsman asked a different question in Section 100. He's saying, look, this is going to be the regime for claims made 1 April 2010 going forward.
Section 100, subsection 3 gives power to the Treasury to make transitional provisions. Were there any relevant?
Not that I'm aware of. But the judge was right, and to be fair, I understand my learned friend essentially to accept that the ouster issue is very closely tied up with the pleading issue, because if it is right that that claim was pleaded prior to 1 April 2010, then really that's the end of it on the ouster point. So I do say that actually the construction of Section 100 sub 2, it's that there's quite a simple question being raised. It's simply this: on what date was the claim made? you don't need some further inquiry into what is the date of payment. Because on the revenues analysis, you would end up with whether a claim is ousted or not. That question, it may well depend on the view that the court ultimately took about when the cause of action in restitution was actually finally perfected. So, for example, if the court had held, which it might have done before investment trust companies and the Supreme Court, that actually giving up the value of the reliefs gave rise to cause of action in restitution, so the point that was rejected in FI Court of Appeal 1, then maybe the claim would not be ousted on the revenues analysis, but actually if it's the later payment of tax, then they say, well, it would be. But that involves an inquiry into the substantive merits of the claim, which is a slightly eccentric approach. If what one's actually doing is construing an ouster clause, which is intended to avoid there being substantive inquiry on the merits.
What is wrong with this simple proposition that a claim in section 100 means a claim of the type identified in paragraph 51(1), namely, the person has paid an amount by way of tax but believes the tax was not due, or there's an assessment. We can leave aside assessment.
Because if that's what the commencement provision is interpreted as meaning, it's still not apt to apply to the prior claim. What section 100 is doing is putting in place a new statutory regime.
You could, before this
Yes.
section, if you have paid an amount by way of tax but believe it was not due, you
Yes.
can bring a woolage claim or you can bring a mistake-based restitution claim,
Yes.
provided you can satisfy the requirements. And that could have been done by claim form, and is indeed exactly what you say you did
Yes, that's
in
right.
relation to the to the 1995 payments. But if you treat claim in section 100(2) as being a claim of that time, then whatever you did in 2003 and 2009, you did not bring a claim as a person who had paid an amount by way of tax but believed it was not due in relation to 2017 and 2018 payments.
And what I'm saying is that wouldn't be a permissible construction, because what you would be doing is cancelling a claim that had already been made and was on foot. That would be like a repeat of the section 107 Finance Act 2007 point.
That's an EU law point.
It would be, yes. And Manfred hasn't, as I understand, actually asserted that construction, but it would give rise to very serious difficulties, because you would you have to approach this question, or the question that's just been put to me, on the footing that I've got that claim in place already, because if I'm wrong, I've lost already, and we're not construing section 100.
Why would it be an EU problem? I thought EU law did allow you to give time limits for EU law claims, as long as they were not in breach of the principles of equivalence and effectiveness. What you can't do is shut out a claim which people haven't brought without a transitional period.
My lord, the point is the claim had already been made.
But isn't the point that para 51 gives a statutory claim? So isn't the argument that that's what gives complies with the principle of effectiveness?
My lady, with respect, no, that's the error that the Court of Appeal made in FII Court of Appeal 1. They thought because you had the Woolwich claim, the mistake claim could be retrospectively cancelled. And that was wrong in Supreme Court
Well,
2.
is it much more than a procedure? It's saying, instead of going through the courts for these claims, you now come through the statute.
But my lord, no, what is not legitimate and not permissible, and I'm sorry, I don't have the reference in FI Supreme Court 2 to hand, what you cannot do is faced with a step which was taken at the time, and on this hypothesis the step was taken in 03 and in 09. If I'm right so far, there was a claim before the courts which was on foot, made in accordance with the applicable requirements. FI Supreme Court 2 and the Supreme Court tells us that that claim cannot be retrospectively cancelled. That was what Section 107 Finance Act 07 tried to do. And it did not matter that an alternative claim might still be available. So that's why one can't construe Section 100 in the way that my Lord Justice Nugee has just put to me in my respectful submission. That was the point where there was an agreement, certainly of a majority in FII Supreme Court 2, and the Section 107 question was not referred.
And this is FII SC2.
Yes, it is, which is actually in the bundle.
Yeah.
At tab 28. And I'm so sorry. I'm so sorry. Did I say SC2? I'm very sorry. I meant to say SC1, FISC1 in 2012. It is in the bundle of authorities, tab 28. It is also exceptionally long.
And it's also that's all about the discussion of section 107.
Yeah, 320 and 107.
Right.
Last point on this. Last 2 points on this, and then I need to deal with issue 3. The revenue relied in its skeleton, this was 34 sub 3, on a potential for abuse. The point wasn't pressed orally in my submission rightly. What was said in writing was, well, there's a problem on the claimants analysis because claims could be made decades in advance of their accrual, and so you could outmaneuver the ouster. If you knew it was coming, you could make a claim for all the tax I've paid for the next 100 years. That wouldn't work for 2 reasons. The revenue would simply be able to ask for further particulars and seek a determination if such a claim were made, but also there'd be jurisdiction to strike out such a case under 3.4 if the claim is being brought for a collateral advantage with no intention to prosecute it. It'd be a classic case for strikeout. So one doesn't need to do any violence or come up with any revenue-friendly interpretation of Section 100 to deal with the potential for abuse. There are much more direct ways of dealing with such problems if they were to arise. The other problem in the revenues analysis is the one which we set out at paragraph 45 of the skeleton, which I don't have time, I regret to develop in detail, but I do say, and I adopt what I said in paragraph 45, that it seems on the revenues approach that there's serious doubt about how you would actually bring a claim at all. I understand the revenue to say, well, you just bring a statutory claim after 1 April 2010, but that isn't an answer, because the revenue's own position, as we know from the post-prudential closure notice, group litigation, and they've persuaded the upper tribunal that this is right, this will be up for debate in this court in January, is that you cannot use paragraph 51 to claim additional double taxation relief. That was a submission that my learned friend Mr. Ewart made to the upper tribunal, which it accepted at the start of this year. So it's highly doubtful actually what the statutory mechanism is in this particular circumstance on the revenues case. There certainly isn't a simple statutory solution here, and the sort of complications we're discussing, they are in our submission a sign that the revenues analysis isn't correct. Can I deal lastly, I'm conscious of the time, with issue 3 and the income tax set-off. This is in the response skeleton, paragraphs 46 to 65. The facts I can take from High Court 134. Put short, AXA should have had these credits available for carry forward in 92 to 94. There was a corporation tax liability in 95. Corporation tax liability in part met by a set-off of income tax. What we're dealing with is how do you go about computing the restitution in those circumstances? Have the carry forward reliefs been effectively wasted? Is it the case that AXA has a restitution claim in 1997 because the reliefs in fact carry forward, which is what I say happened, what the judge found? Or is the consequence of Milena Friend's analysis actually that there should have been a restitution claim in 1995?
Well, isn't it I thought the revenue said should have made a statutory.
They do, but what they haven't answered, what they've not faced up to, is the point that the statutory regime was not exclusive. So Section 7 of the Income Tax Act, which my learned friend quotes in his skeleton, it makes clear you get the money back. But this is before Para 51.6 comes in. We're, what, 15 years before Para 51.6 comes in. So the statutory remedy is not exclusive. So if my learned friend's right, that DTR was should have been applied in 1995, the income tax was repayable, there's no reason at all why I can't get that back in a claim in restitution. I've still got an overpayment of tax, the revenue's got value, okay, it's not been paid by me directly, that doesn't matter. There is a transfer of value, and there's a mistake. So there's no reason why I can't get it back in 1995 if my learned friend is right about everything else. There are two real issues between us on this. The first is how you interrelate FII Supreme Court 3 and Prudential Supreme Court. And the second is the point I've just made about 1995. The key point on FII Supreme Court is that the Supreme Court's approach is that ordinary reliefs and set-offs, they're not the source of the unlawfulness and they should not be changed. And one can see that in particular in two places in FII Supreme Court 3. So authorities, volume 4, tab 37. Paragraph 121, electronic 1348. Between letters C and D, the Supreme Court is absolutely aware that there are different reliefs, some of which may be set off, as it says in line 4, against profits, or against the tax which was prima facie chargeable on those profits, depending on the rules applicable to the relief in question. So that's point one. They absolutely know that there are different ways in which reliefs may come into the computation. And point two, if one looks at their treatment of group relief in paragraph 127, 1350, it doesn't matter whether the application of the relief is automatic or not. You can see that when the Supreme Court says first it wasn't automatic but required the making of a claim under the letter C.
So were you 127, did you say?
Paragraph 127, page 1350, between C and D. It didn't matter that group relief was not automatic. And as I showed the court earlier, the vice, as the Supreme Court found, was in the DTR system, and if it could, the solution was to be found there too. And what the Supreme Court identified was those two possibilities in 145 and 146. Either the reliefs are still there, or tax has been paid, and it can be got back. And what the Supreme Court is focused on is that corporation tax becomes excessive when, if those lawful reliefs and set-offs are left in place, tax has been paid, which wouldn't have been paid if the double taxation relief system had allowed the carry forward of the DTR. That's the whole thrust in my submission of Supreme Court 3 at paragraphs 146 and 154 to 158. It's identifying tax paid. What my learned friend says is, no, that doesn't work because of Prudential Supreme Court. And I say that he's putting on Prudential Supreme Court a weight that it won't bear. That's in volume 3 of the authorities, tab 32, starting at page 1044.
page?
It starts at 1044 and then issue 3 starts at 1084. And you can see at paragraph 87, for example, that the Supreme Court's dealing with quite a specific issue in relation to computation. And the premise of the issue is that you have these amounts that are described as lawful ACT and unlawful MCT. And so this is all being approached on the footing that under the relevant conforming interpretation, the ACT charge was lawful, but that the mainstream corporation tax charge was unlawful. And as we saw with my friend yesterday, the Supreme Court's answer focuses on the construction of section 239. And you can see that in paragraph 97 when they identify the logically prior question, has there been a set-off? They weren't being asked to deal with the question that arose even before that, of when is it that the unlawful tax charge arises. That's the question that's being addressed much more precisely in FII Supreme Court 3. The premise of issue 3 in the Supreme Court in Prudential is that you've got these unlawful amounts and lawful amounts, and then what do you have happening in a purported set-off situation? Answer, paragraph 101, bottom of 1087, there is no set-off because the unlawful charge is a nullity, and then 102, you can't have a restitution claim. Because there's no defective transfer of value because the tax was due and it was available to Prudential to utilise thereafter. So that doesn't give rise to a restitution claim.
Is there a difference here? If it had been understood that EPR could be carried forward into the 1995 period, that would in fact have extinguished the Corporation Act and would in fact have allowed an income tax reclaim if the crystal ball was there.
I'm so sorry, if the...
crystal ball was there and
yes.
everyone understood.
Yes.
So if everyone had understood the position, an income
Yeah.
tax reclaim could be made. In contrast, in FII, it's held that there was a lawful offset of the losses in stage 1. That's the thing I'm struggling with. It's impossible, and the law as we understand it now, for the to say that the losses weren't effectively set off. They were effectively set off, and the problem is in stage 2. Whereas here, we've got a set off of lawful, if you like, income tax, akin to lawful ACT, against an amount which we now know shouldn't have been charged.
Now, I'm in danger of getting the sort of the here and the there muddled up in my own mind. I think I understand the question. That these, if I can answer it in this way, you can see why the claim failed in Prudential in 102. That the way that 239 worked for ACT, critically, was that the taxpayer didn't automatically get back the ACT. It might carry forward. It might be able to elect to carry it back. There were various arguments about what that meant for the claim in restitution, but the claim before the Supreme Court was focused on the moment of utilisation. And that's why they say at 102, well, that tax was due when paid and was available to PAC to use thereafter. What the Supreme Court is not having to deal with, because this was an assumption in the argument before it in Prudential, is actually whether that charge of what's described as unlawful MCT is that actually to be, do we actually have in law an unlawful charge or not, essentially? When you read the description of issue 3, it's taken as a given by the Supreme Court that that's the position. I'm making 2 points. The first is that now that we have FI Supreme Court 3, we know that ordinary reliefs aren't to be disturbed, and there's no difference conceptually between applying ACT and applying income tax in that context. And it is, at the very least, instructive that in Supreme Court 3, the court makes clear that its analysis of the DTR being carried forward, they say at the end of paragraph 105, page 1355, that result is consistent with the treatment of unutilised lawful ACT and prudential. They think that having the carry forward of DTR is consistent with having the ACT carrying forward in prudential.
So is that the end of 105?
145, towards the top of 1355. So my first point is one has to actually take on the question, which is essentially a function of assumption in prudential Supreme Court. Have we actually got unlawfulness or not in the relevant sense? And one has to do that particularly against a background where the Supreme Court 121 of prudential of FII SC3 is well aware that reliefs may apply against the profits or against the tax. There's no principled distinction for saying, well, if it's against tax, it's one thing. If it's against profits,
so you're
it's another.
essentially saying there was no unlawful MCT in 2005 on our
In 1995, on
our facts,
on our
because it was automatically
Yeah.
absorbed by the
Yeah.
income tax set off, just in the same way that other reliefs
Yeah.
considered
That's
by
the first point. And then the second point is, suppose that is wrong, you've got to ask, well, where would that get the revenue? It would get the revenue to a place where, as in prudential Supreme Court, the set-off of the income tax in 1995 was a nullity. The question, does that get the revenue home? Answer, no, because the framing of Section 7 of the 1988 Act is different to what Section 239 did. And you can see this in the judge's findings. Paragraph 133, Roman 3 in the judgment, page 121. It's Roman 2 and Roman 3. AXA was entitled to repayment of the excess income tax. Contrast what happened under Section 239. In the ACT world, you weren't able to ask for repayment of the ACT. You had to either carry it back or it was then available to carry forward. You couldn't simply say, give me the money. Section 7 and income tax was different, as can be seen from that paragraph in the judge's judgment. So that income tax suffered by deduction, it should have been repaid to AXA. My learned friend then says, well, you needed to make a statutory claim. And my answer to that is, well, there's nothing that says that I'm restricted to a statutory claim. So the High Court claim is good enough to get you home. On that hypothesis, it would have to be in 1995. And that, of course, would need the extended time limit. And then whether that's time barred or not depends on what this court says about issue A, and if the court's against me on issue A, what the findings ultimately are about what the date is. But that's the analysis in my submission. So first of all, the revenue is not properly interpreting FI Supreme Court 3, putting a weight on prudential that it weren't there. And secondly, the consequence, even if the revenue is right, and you do just apply prudential Supreme Court, because the consequence of Section 7 is critically different to Section 239, you have a claim anyway. I'm very sorry to go over my time. Just give me one moment. I'm very grateful. Those are my submissions.
Thank you. Yes, Mr. Wilmot-Smith.
Grateful. Mr. Bremner would portray me as a fusty old philologist when I come to construing the statements of case. He said that I construed them as if they were a statute and too strictly, and that there had to be some allowance for the fact that these were developments at the, I think the quote was, frontier of legal developments. And in my submission, that is the crux of the issue on the pleadings question, which is whether his clients are entitled to special treatment because this is a complicated area of law. That was also the way I should say he put it on the futurity issue. He said, because there it's a complicated issue, then he was again entitled to some form of special dispensation on what the meaning of liable to be paid is. Now, in my submission, once that question is posed, and we realise we're not dealing with any special bypass to pleading rules, the answer is that my appeal must be allowed, because on any ordinary reading of the pleadings in issue here, the causes of action now sought to be asserted were simply not there. So if I'm right on that, and if I'm right that there's no difference here with a vanilla case, A against B, then I say my appeal should be allowed on that. The position is, we know from Salonen and from FII how the EU law unlawfulness arises, and also how a domestic law remedy can arise. They say nothing about when a claim at the stage 2, where there's a failure to carry forward DTR and set it off, has been pleaded. And the question is, did they assert the causes of action they now want to bring against the revenue? If they did, they'll win, subject to the point on the ouster. But if they didn't, then they can't win now because it is an EU law claim or it's very complicated or anything like that. That's my first point. The second is Mr. Bremner conceded an answer to a question from my Lord Justice Nugee that he couldn't bring a mistake claim for the 2018 and 2019 payments because it was 15 years after the accrual. That took the wind out of one of the sails I was going to seek to raise, which was to make that point. We agree, but we also say that the same analysis must apply to the Woolwich claim on unlawful demand. In his second particulars of claim, on the second particulars of claim of AXA, paragraph 12, which is supplementary bundle, page 122. My reference must be wrong there.
I think it's page 12.
That's more like it than anything. Thank you. That's where the unlawful demand claim is put in 2009. And the assertion is that the dividend provisions constituted an unlawful demand of tax. So it's a Woolwich claim. The tax is paid in 2018 and 2019, so the allegation must be that there was an unlawful exaction in those years. And we just don't see how it can be said that in 2018 and 2019 the dividend provisions were an unlawful demand. They've been repealed by that point. The dividend provisions, I should say, are defined at paragraph 9 of the pleadings, page 11. I understand, all foreign dividends were exempted by 2009. I think Mr. Bremner's answer to this from his submissions were that they were somehow locked in from the original position. And that makes it sound like a Woolwich injustice at stage 1, which is echoing through time till 2018 and 2019, and that's resulting in the demand. But he's going to need more than that, given what the Supreme Court says in FII number 3. The paragraph 157, just to set it in context, we said in FII number 3 that the later payments couldn't fall under Woolwich or any domestic unjust enrichment claim because they were lawfully owed under the demands made at the time pursuant to the statutes. So there were statutory claims that they were being that the money was exacted in pursuance of. That was slightly inelegant. You understand what I mean? And we said, well, those statutes were lawful, and so it must be that there's a bar, which is that there was a valid obligation to pay. The Supreme Court at 157 says that we're wrong because they're unlawful. That's at page 1357. And that must mean that part of the unlawfulness is the stage 2. but all his particulars plead is the dividend provisions, which is stage 1. So the same point that my lord was putting to Mr. Bremner, we say applies to the Woolwich claim. Third point, the futurity problem as it's now been described. At some points today, Mr. Bremner said, I had to put my case this high as to say one couldn't do that. I don't have to put my case that high, I do, but I can put it also at the position they didn't make these claims. Your lordships and your ladyship do not need to decide whether one can in principle do that, if in fact they didn't. Mr. Bremner's position is, though, and he has to convince you that one can do that, because he has to say that either the 03 or the 09 pleadings asserted those later payments. Now, if he's right, Section 35 of the Limitation Act, precluding the introduction of causes of action, can be walked around quite easily by pleading that happens to refer in some generic sense to the future. And proof of that is that if he's right, that's exactly what his clients did here in respect of the ouster. The ouster is introduced before the payments, but he says, my claim was introduced in 2003, so it doesn't matter that the ouster is there because it doesn't apply to it. That is walking around the ouster, we say. And he says, that isn't a response because my clients, HMRC, or any client in that position, could simply seek further and better particulars or seek to strike the claim out. How? If you received the particulars that the court has seen, how could you ask for further and better particulars on a claim that wouldn't accrue till 2017 or 2018? You don't understand that. More pointedly, how could we have struck the claim out? The pleadings asserted a valid claim for restitution of tax paid on tax levied and then paid on the dividend income received. We couldn't strike that claim out. Then where does one look to see this other claim? We don't see the words that we could strike out. We don't see the claim. You can put the point also...
Liable to be paid?
Well, then that isn't a claim for money. And so we'd say it simply wouldn't apply to the claims they now want to bring. If we had struck that out, then if Mr. Bremner's case is that his claim rests entirely on those words, then it is a very thin foundation on which to build the entirety of the other claims. But yes, I take your lordship's point. Mr. Bremner, though, I think didn't put it that way. He said instead, we could have struck out the claim. That was the language the court will notice he used, sensibly given his position through this morning. He never said we could have struck out the causes of action, because there were no causes of action pleaded. There's nothing there we could have applied to strike out. And that point can be illustrated or made more acute if the court imagined that his clients had particularised the earlier payments properly in the schedule. Pleadings are exactly the same, except the schedule does disambiguate the stage 2 payments accruing or being paid before the claim form is issued. And we say then, well, you have the futurity problem for the later payments. His response is, no, you could have applied to strike them out. But again, where? Perhaps he'd say what my Lord Justice Lewison has said, but I don't think that is what he said this morning. On ouster, I may not have heard Mr. Bremner on this, and so I apologise if I am putting words into his mouth. I think he said that I said, if the pleading issue is in his favour, then in a sense what the judge said is correct, and that the ouster issue falls away. That's what the judge decided. If he didn't put the case that way, then I apologise. And in a sense, it doesn't matter. What matters is that's not what we say. We say there is an additional point. We wouldn't have needed our ground on ouster if it was just pleadings. And our point is, as I hope the court appreciates, even if they had pleaded this wraith-like cause of action, the 2018 and 2019 ones, in the claim form. It's one that hadn't accrued, and therefore it was one which it's possible to oust, we say. And the question is, as my Lady Justice Falk put it to Mr. Bremner, on the true construction of the statute, does it exclude such claims? And we say it obviously did. The purpose of the ouster is to ensure that all of those claims falling within subsection 1 are channeled down this route, claims for money paid or assessments. Why? To ensure that HMRC has a single procedure to process them all. On Mr. Bremner's approach, the ouster doesn't do that, where claims are issued but haven't accrued before the ouster comes in. So I come back to my Limitation Act point, which is the more general way of putting it. And he says, what I say, which we would submit is simply the plain reading of the statute, what its words mean, can't be right because of an EU point. This was the section 107 analogy to FII. Now, I don't think that point is in his respondent's notice. I think it's a new point that I'd not heard till this morning. So my first position is it's just not open to him to make that submission. The court will be with me or not on that. And so on the substance, I'll say it's not like a section 107 claim, because section 107 and all EU law cases concerned with ouster are concerned with ouster of causes of action, of rights that people have. Those you cannot get rid of without transitional periods and so on and so forth. But there's no EU law case I'm aware of which has said claim forms are protected. Claim forms asserting future causes of action are somehow protected by the EU law principles.
There is also a transitional, it's effectively a transitional provision because there was delayed implementation.
That's correct, my lady. I think Mr. Bremner's answer to that was, and I in a sense sought to cut to the chase, that doesn't help because it's taking away an accrued right.
Well,
As
is
I
it?
understood it.
I just wonder about that. I mean, if the legislation had said all pending actions are to be transferred to this particular procedure for reclaiming money, if you had a right, you can still enforce it, but just in a different way. And if you didn't have an accrued cause of action, you had however long it was between July and April to assert your right.
I hear everything your lordship's saying. I don't want to gainsay it, but I'm also nervous about endorsing it for the
No, I
reason I've
follow.
already said.
Well, I mean,
I was not prepared to make submissions
No,
on EU
quite.
law on this because I didn't think it was an issue. And I just don't remember clearly enough how the section 107 point was decided in FI number 1. What your lordship says makes sense to me, but I don't feel musical enough on EU law principles to speak as a off the cuff. If I'm right on that, then that will cover, even if I lose on the pleading point, the main payments that they now seek to assert. Even if I'm not, in my submission for the reasons I've given in writing, we've given in writing, and I've said, we went on the pleading point, which gets rid of all of them. The one additional point I might make is on the 2009 pleadings, if the court were to find that those introduced the claim, there may then be a debate about whether it's in time or not, depending on what the court decides on Mr. Ewett's response on limitation. I think this would be a point for later to deal with the order, but I just wanted to lay down a marker. I didn't want to be taken to accept that if there were claims there, then they get home. It will just be a more complicated issue on the order. Unless the court has any questions, I would hand over to my leader.
No, thank you very much. Yes, Mr. Hewitt.
Can I just say something very briefly on the EU point that you were debating, and it may or may not help? The EU law cases on this have all been in the context of situations where taxpayers have accrued rights to make claims, and they've been taken away instantly. So one day you had it, you thought you could bring it in the future because you were within the limitation period, and then it was taken away by the shortening of the limitation period or something. And what they say then is, well, a transitional period is sufficient to allow that because you're given 6 months. You're told we're going to take these claims away in 6 months' time.
Yeah.
You've got 6 months to make them. None of them deal with this kind of situation where the claims, where it's not accrued. It just doesn't work. This is supposedly a claim made today where it's not going to accrue 7 years or something. So, that's not the kind of thing the European court cases are dealing with for obvious reasons. But that's the answer. And I think the answer is not a breach of effectiveness, not because you might have another remedy, you might have, but because you had the chance in that 6 months to bring your claim. And if you don't bring it within that 6 months, then you've lost it. And that's regarded as being fair by the European court. That's what happened in Para 51. It was enacted in legislation, but wasn't brought into force for about 8 months. So everyone knew what was going to happen, and they could bring the claim.
Yeah.
Anyway, I don't know if that helps, but it's not the kind of situation we're dealing with today, I think, which is rather more subtle. Can I just say a few words about issue 3? These are things I think I've said already, actually, in response to Melanchthon's argument. We say there is a direct analogy between the present kind of situation and the situation in Prudential with ACT. There is an unlawful charge to corporation tax. There was in Prudential. There was a lawful charge to something else. In Prudential, it was ACT. In this case, it was income tax. The tax that has been lawfully charged is then set off against, under the provisions, appears to be set off against the corporation tax charge. But the Supreme Court said it's not set off because the corporation tax charge was unlawful, now known to be unlawful. The situation, and I think the distinction between that and the kind of case in Supreme Court 3 is that in that case, there is no tax liability because of the reliefs. The reliefs go to reduce the chargeable profits, so there's nothing to charge. And so tax is not being discharged by a set-off or anything like that. It just didn't exist at all because of the use of the reliefs in the UK system. So that, as I see it, is the distinction between these cases. I think my learned friend was getting close to saying, actually, in the light of Supreme Court 3, Prudential is wrongly decided. But that's not something for this court, obviously, to decide. If you're trying to, you do have to reconcile the two cases in my submission, and that's the way I would submit they can be reconciled. And there is no distinction in principle between the position of income tax and ACT. They both have statutory consequences. They are different consequences. ACT carries forward or carries back. Income tax was repayable, but they both have statutory consequences. And the final point about having a restitutionary claim, well, that was one of the arguments I think my learned friend was making in Prudential unsuccessfully. They were arguing they should be able to recover the ACT in restitution. And the answer to that was no, the ACT was lawfully charged. Nothing wrong with the ACT. It just carries forward. And we would say, and similarly in this case, the income tax was lawfully charged. There's no question about that. It wasn't set off against a corporation tax liability that didn't exist, as we know. And therefore, the consequences are simply the statutory consequences. There's no ground for recovering them in restitution. There's no EU law right to recover them in restitution. We would submit. And that's.
So what do you mean? Are you going to answer the Section 7 point? The point being made that even if that was right and the income tax could have been reclaimed, under Section 7 of the Taxes Act, that doesn't exclude the
Well,
common law.
In my submission, it does. I mean, this is not a point I don't
I
think.
mean, no one's
really-
referred to autologic, but it's
No, I think
it's referred to
it's
in the
actually not
submissions.
that. I think it's a case called Monroe.
I thought your point was that because income tax had been lawfully charged, there's no ground for repaying it.
Well, there is a statutory ground for claiming recovery of it.
But that would depend on it having been overcharged, wouldn't it, or not?
No, it was properly charged, but if it's not set off in the year,
Oh, I
the
see.
statutory provision says you can claim to have it repaid.
Right.
So purely under the statutory provisions, you've got two possibilities. One, you set it off. The second is if you can't set it off,
Right.
you claim to repay it. And in a domestic context, there is authority, as a case called Monroe, that statutory provisions for recovery of tax do oust common law claims. It's only in the European context that that's been held not to apply. It was held not to apply. In a purely domestic context, then there's authority that does exclude. So
so, but
if
we
there is a
are in a, sorry, just,
Yeah.
maybe I'm being slow, we are in a European context.
but not in relation to the income tax. My submission.
The income tax wasn't unlawful under national EU law.
No,
What was the
the recovery of the income tax is purely a function of the UK statutory provision.
So you say the autologic, which I think Mr. Bredner was relying on a case called autologic to say you should have a common law remedy, even if we would say if you're out of time on a statutory remedy. Here, they're out of time on a statutory remedy, which would have been to bring a claim to repay the income tax. He says you can bring a common law claim, and you, as I understand it, you're saying because for these purposes we're really looking at a domestic provision, Monroe applies.
Yes, exactly. That there is a yeah. There is a second point, and the reason I think the only reason one of the reasons we're here is because there wasn't actually a claim to recover the income tax. So if it's being said there was a claim, then we go back to the pleadings point because there's certainly no claim to recover
I see.
income tax. On any view, there's no claim to recover income tax in these or any circumstances.
Well, maybe that's perhaps more relevant on the Monroe point.
Yeah, well, I think both, but yeah. Because if it had been said we can recover it, I think that would have been an issue. Would have been dealing. Sure, that's really.
Forgive my ignorance, but what does Monroe say?
Well, Monroe is a case which says that if there's a statutory, this is purely in a domestic context, if there's a statutory remedy to recover tax, that has an implicit ouster of common law claims. I mean, there's a whole line of authority about that in other contexts that statutory provisions can oust common law claims.
Yeah.
And that was an example of it in relation to Section 33 of the Taxes Management Act, I think. So, unless there's any further questions, that was a submission.
Thank you very much. Well, thank you all very much for your very interesting arguments. There's a great deal to think about, so it will not surprise you to learn that we will reserve our judgments. You will get draft judgments in the usual way. That's your chance to correct our English but not our reasoning, or to introduce new points. In the light of the draft judgments, we would hope that you can agree in order disposing of the appeal, but if you can't agree in order, please make short submissions in writing and we will make the order that you consider to be appropriate. The draft judgments is restricted to those on the distribution list which has been given to the court, and when the judgments have been finalised, they will be handed down remotely, so there'll be no need for further attendance. Thank you all very much.
Spill.
water rather than